That the Labour MP, Simon Danczuk, might use the cover of parliamentary privilege, which in effect gives a politician legal immunity, to name a person or persons who'd been the subject of the child abuse accusations. The use of privilege has long been an invaluable means for MPs to right wrongs. But there have been occasions when a person's reputation has been unfairly ruined because it turned out there was no supporting evidence. So do the rules on parliamentary privilege need to change? I spoke to Richard Gordon QC of the Constitution Society, who wants to see reform, and to the Liberal Democrat Member of Parliament, John Hemming. First, I asked Mr Gordon for a quick definition of parliamentary privilege.
Well, parliamentary privilege is the claim by Parliament to be able to debate freely and without interference from any other place, including the courts.
And what value is that?
It's extremely important in a democratic society that Parliament should be able to conduct its functions effectively, that MPs should be able to freely speak in the chamber without fear of interference by anybody else. It started off, actually, as a claim to freedom of interference by the King, by the Crown, but it's gradually become much more a relationship with the courts.
Now, John Hemming, I'm tempted to say you're a serial user of parliamentary privilege. You've certainly used it in a variety of different ways. Why do you use parliamentary privilege so much?
Well, why do I concern myself when things are going wrong in the judicial system? We have a three-estate constitutional structure in the main, and if things are going wrong in the judicial system in secret courts, then I raise that in Parliament. So I have actually spoken a number of times about flaws in family court decisions, and that, of course, is potentially a contempt of court if said so outside a Parliament. In fact, I've just done an interview on Brazilian television, which if that was broadcast in England, we broadcast the programme we broadcast in Brazil, it would have been subject to the law. So it is important to have the facility to talk about what's going wrong in secret court. You
famously brought up the name of the Manchester United footballer Ryan Giggs in the Commons chamber. And I think I'm right in saying that when you did that, you were actually heavily criticised in the following days.
I was criticised, but in fact that instance wasn't used in contempt of court because 24 million people knew his name. And if you followed Spycatcher judgment, which was that if something is published in Australia, it's not confidential in England. If something's published in Scotland, it's not confidential in England. So actually, that's not a good example.
But it was seen as a bit of a frivolous use of parliamentary privilege.
But it wasn't, in fact, something which was... I think, to be honest, the fact that they were trying to potentially imprison 75,000 people for tweeting something highlights the absurdity. And what I was doing was highlighting the absurdity of attempting to punish 75,000 people for making a joke.
Richard Gordon, do you want to see a change, a fundamental change to parliamentary privilege?
Yes, I do, and some of what John's just said illustrate why. The thing is that parliamentary privilege can be misused. I mean, to say something's gone wrong with the judicial system so I can broadcast it throughout the land could be seen by judges as actually an interference with the independence of the judiciary. What I'd like to see is parliamentary privilege brought up to date, parliamentary privilege codified so that we had a very clear set of rules rather than an Act of Parliament which goes back to 1689. That's the sole basis in law on which we have rules about parliamentary privilege.
But when you say codifying, what you're really meaning is a Parliamentary Privileges Act?
A new act, exactly, as they have in Australia, as they have in many places where people know exactly what Parliament can and can't do, what it can and can't say, and when it's actually in fact and in reality flouting the law.
It's fair enough, isn't it, John Hemming?
Well, the law, what my colleague here is suggesting is that we should not be allowed to criticise judges in Parliament. In fact, it's very clear that Parliament has a function for criticising judges. It has happened from time to time. Parliament has the power to remove judges under the 1701 Act of Settlement.
Parliamentary privilege goes well beyond what John's talking about. In other words, the freedom of MPs to comment on matters that they perceive to be in the national interest. But it actually goes to things like committees of Parliament and many other things.
So would you take privilege away from all the select committees?
No, I wouldn't. I think having privilege in a select committee is important. I mean, a select committee is a proceeding in Parliament and therefore is subject to parliamentary privilege. The real concern about committees is that some of them, not many, but some, tend to go over the top and demand information which other laws actually prevent them from having.
So what limit would you set then for where would the boundary of parliamentary privilege be?
I think the boundary of parliamentary privilege would, in my opinion, come to this, that if a witness in front of a committee committee had a good reason for not answering a question, they could put that good reason, have it considered, and certainly not have it judged by a committee, however eminent, as being in some way a contempt of Parliament.
Now, what about the Rebecca Brooks incident? Several years ago, she said to a select committee that her newspapers had paid the police for information. That could not then be used at her trial because it was covered by parliamentary privilege.
It's partly the Pepper v. Hart issue as well, which was looking at the extent to which you can use things in
So does that show parliamentary privilege breaking down?
Well, no, and I think we do have a clear disagreement here, which is that I do think it's important for politicians, backbench politicians, to be able to criticise judicial processes subject to the sub judice motion. So we have a principle that you don't criticise them before they're made. You don't try and influence the decision. What you do is you raise concerns as to how things have happened in the judicial system after the decisions were made. I think that's an important part of how the system works. And I would not want to see parliamentary privilege restricted so that judges are given control over Parliament.
Well, and in the present situation where we are, the present climate, with the talk of a Westminster paedophile ring and an MP who was thought going to be using parliamentary privilege, that does create the danger where names are suddenly got out and they're almost guilty in the public mind without any evidence.
That did happen on Twitter, of course, but it actually hasn't happened in terms recently in Parliament, has it?
Do you think that will lead to a change, both of you, John Hemming?
Well, the point to remember about Parliament is not, you don't have complete freedom of speech. You're still subject to the rules of the House and the decisions of either the Standards or Privileges Committee. So you don't have complete freedom of speech at all.
I'm tempted to say, if it ain't broke, don't fix it. Why are you so keen on changing?
Well, it'd be great if it wasn't broke, but the answer is this. We have an Act of Parliament several hundred years old. We need a new one to cope with the modern climate. You've mentioned Twitter. John has mentioned the judiciary, what's gone wrong with some judicial cases. Maybe something has gone wrong, but the relationship between law and politics should not be one governed by mistrust of judges. It should be governed by judges and politicians working together harmoniously in a modern age.
Richard Gordon, John Hemming, thanks very much indeed for joining us on The Week in Parliament. Some thoughts on privilege. Now a look at some of the other stories around